oath, would you lead us in salute?
Pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you for coming for a special meeting. I have a roll call of officers.
Mr. McKevitt?
Here.
Councilman Molina? Mr. Davis? Mr. Kelly? Ms. Lee? Here. Mr. McEnroe?
Present.
Ms. O'Leary?
Here.
Mr. Velosan?
Here.
Ms. Matilla? Here. Chairman Pai?
Here.
Mr. Rogoff?
Here.
Mr. Cornell?
Here.
Mr. Luvella?
Here.
We have a quorum.
Thank you. Old business, new business, administrative matters. We're here to discuss and consider the adoption of the amendment of the element of fair share housing plan. Review the recommendations to the COA ordinance, ordinance 44819, new affordable housing districts, AH1-AH-2, ordinance 44919, new affordable housing district, AH3, ordinance 45019, development of the revised general ordinance of the Borough of Saraville to permit affordable access apartments in the office service overlay zone, ordinance 451-19, adopting the River Road redevelopment plan. And that's what we're going to do. Mr. Barry.
Yes, good evening, everyone.
If you would give us an overview from Mr.
Happily.
Okay.
My name's John Barry. I'm with Higher Gruel and Associates. And the purpose of the review this evening is really just to readopt the housing element and fair share plan, and then we'll discuss the ordinances. We'll start with the housing element and fair share plan. But the purpose really this evening is to tidy up some things that were left over at the end of the process of going through the settlement agreement with the courts and their order to finish tidying up all the documents. These were adopted last summer. Last June was a fairness hearing, and then there was an order issued in August of 2018 that approved all the settlement agreements between the borough and the various parties. And then we had a compliance hearing in November, and finally the final order from the courts in December 2018, so 4.5 months ago, give or take.
Before you continue, let's just identify, your involvement on the record with this.
Sure.
And I don't remember the last time when Ms. Rule was here whether or not I swore her, but I think that's probably the best thing to do anyway to make a record.
You might as well, yes.
So.
Excuse me, Mr. Chairman. You're required to read a statement at the beginning of the meeting that the meeting is being held in accordance with the
Oh, I'm
provisions of
sorry.
the Open Public
You're
Meetings Act.
absolutely right.
I would hate for all this.
No, Jimmy,
The
you're right.
attorney should have pointed that out.
Being a special meeting, I overlooked that. Beth,
Yes.
has this been notified in the Open Public Meetings Act
Yes, Chairman, it has.
and in the paper?
Yes, it
Thank you
has.
very much. Thank you, James.
Is it being televised, being recorded so it can be shown on Cablevision?
I believe it is. There's a,
In this room it is? Okay, I didn't know if
Okay.
this room was being filmed. Thank you.
Yeah, please stand and I'll swear you in.
Sure.
You swear the testimony you're about to give the board, you have to raise your right hand. You swear the testimony you're about to give the board in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
You want to give us your name, your credentials, and your involvement in this matter?
John Barry, B-A-R-R-E-E, planner with Higher Gruel and Associates. I'm a licensed professional planner in the state of New Jersey, member of the American Institute of Certified Planners. Have
need a
a-
motion to accept his credentials.
Make that motion.
Second.
And my firm prepared the report, the plans, and worked on the various ordinances and housing
Your-
settlements.
Your firm also prepared the report, that I think it's a two-page report.
Is it the dated April 16th,
Right.
two-pager, essentially a summary of the changes and why we're here this evening?
Let's make that a part of the record. We'll identify it as A1. We'll make it put into evidence.
Okay.
Okay, thank you.
So I'll just start again from fresh since I'm now sworn in. The purpose of our meeting this evening is to review some relatively minor changes to what was the previously adopted housing element and fair share plan, and several ordinances. Beginning with the housing element and fair share plan, the plan was previously adopted in June of last year by this board, and then subsequent to that, there was a fairness hearing with the court on June 28th. Order was issued August 1st approving the settlement agreement between the Borough, Fair Share Housing Center, and then separate settlement agreements between the Borough and NL and K-Land. And then after that, a compliance hearing was held on November 16th, 2018. Essentially, it was wrapping everything up, saying that the borough has done its due diligence and what it has to do to put those settlement agreements into effect. And then on December 20th, 2018, the borough was granted a conditional judgment of compliance and repose. With that, there were some requests from the court master to make some minor modifications to some of the language in the plan. And some of these changes are based on updating some texts and things that had changed. Others were just some clarification language. So I can go through what has changed since the 2018 plan with you. The first change, and if you're following along on the list, the first bullet was updates to the narrative regarding the Riverton development. Formerly, it was referred to as Luxury Point development, and there had been some just changes to how that potential development was referred to in all the documents. So that's been updated. The number of affordable units hasn't changed, but the mix of those potential units and how they'll be distributed in terms of affordability, the different income levels, was modified to reflect language that the court master requested. This was not a substantive change, but it was just a simple change of language the court master was more comfortable with. As part of that, we also updated the maps associated with that project. There was just clarifying the maps that were used before were some older black and white maps that were harder to read. We produced a new color map that had much more clear boundaries of the area that we're talking about. The next update is regarding Gillette Manor. The Housing Authority, the borough's Housing Authority, entered into a resolution on November of 2018 that clarified the income distribution requirements and confirming that for 84 units, those requirements would be in accordance with the Uniform Housing Affordability Controls. So those units have always been affordable, but one of the requests from the court master was to go and make sure that that specific language that's mandated by UHAC, the Uniform Housing Affordability Controls, was in place, and that the Housing Authority had formally agreed to those standards. In addition, there was a March, just several weeks ago, there was a March memorandum of understanding between the borough and the Housing Authority to market 9 of those units to very low income households. So there was a slight change to the income distribution there to account for some additional very low income households and to make sure that we're in compliance with all of those UHAC regulations. The third change was really just to reflect that all of the proposed zoning ordinances regarding the various affordable housing sites that were in the settlement agreement, the NL and K-Land properties, have subsequent to the June of last year plan, those ordinances were adopted. So the language in the plan was updated to reflect that those were no longer proposed, but in fact, the zoning was in place. The next bullet point on the second page or on the back side, however your document is prepared, had a list of all of the affordable housing ordinances and resolutions toward the back of the Fair Share Plan. That list was updated to reflect that all of these ordinances had been adopted, and also to reflect the new amended ordinances that were introduced that we'll be talking about in the second part. So that was just updating a list. That's all that change was. The next change refers to the spending plan that had been included in the June 2018 plan. That was section 3 of the plan, It's been removed from that part of this plan and has been included as an appendix. In November of last year, November 2018, the Borough Council adopted that spending plan by resolution because it has to do with how money will be distributed. It's the governing body's action to take, really. It's outside of the board's control. So rather than include it in the board's housing plan, we've separated it out. It was adopted by resolution by the governing body, and now it exists as an appendix to the housing plan. The appendices were all updated to reflect the current versions of the settlement agreements that were all finalized as after the June 2018 plan was adopted. An updated pro forma for the River Road project, which is the subject of the redevelopment plan. An updated pro forma for that project was included as a new appendix, Appendix W in the plan, to reflect conditions that were discussed in the December court order. And then the last change was a rental rehabilitation manual was prepared by Community Grants Planning and Housing. They currently run the borough's CDBG, the Community Development Block Grant homeowner rehab program, so that for folks who qualify, there's an opportunity to get some money to fix up owner-occupied home that may need some repairs. This new manual would apply to a rental rehabilitation program as well. So that's included as Appendix X of the document. So those are all the changes. It's really just a lot of housekeeping to make sure that everything reflects the current conditions and addresses some minor comments that were put forward by the court master.
These were all consistent with the court orders in this matter,
Yes,
and they were also consistent with the recommendations by the special master, which is under the auspices of the court. Is that correct?
absolutely.
And so this is just a matter of implementing that which is required in that litigation?
Yes.
I don't have anything further.
Anybody have any questions?
Yeah, yeah. There's no questions here from
No,
board.
no question.
Sure you can.
Anybody in the public have any questions with what we just went over? Sir, in the corner? State your name and,
Thomas Pashada, 17 Green Hill Avenue, Bartow, New Jersey. The information that this gentleman read off, is this confidential, or how come it's not published that the people here at the meeting can see this tonight?
It's not confidential.
It's not, no.
You know, usually at a meeting, they have copies that are, I'm talking about transparency, that's what it is. That usually they have copies that, for handouts to anybody that's here in the audience. There's a possibility of getting copies of this that we can have for ourselves for tonight?
yes. We can get your copy.
Okay, I'll come back later on. I
You
have
can
some other
certainly borrow
things.
mine.
I'm not worried about, I'm worried about myself and everybody that's attending.
No, I understand.
You know, so we can get
You
copies.
want my
I would
copy
appreciate it.
to look at?
Well, I
or-
mean, he's read it off. I'd
He
like to
did,
have a
he
written
did.
copy.
Yes,
And I think everybody
I
else
would
here would.
also.
Well,
should have been filed.
it's on file, but, and you could have asked for it, but what we'll do is, Beth said that she could make copies at the end of the meeting.
Okay,
So
yeah.
if anybody
Like I s-
wants a copy, just let me know how many we need, and we'll get them at the end of the meeting.
See, the reason I say that, usually whenever you go to a meeting, there's usually handouts pertaining to what that gentleman was saying.
And then we can prepare questions or ask things. It makes the meeting more
Well,
meaningful.
ma'am, we can only do one person at a time.
All right, thank you.
You're welcome.
Thank you, sir.
James?
Thank you, Mr. Chairman. I agree with Mr. Bashada's points. I'm familiar with what Mr. Barry wrote and had something to do with a lot of it. I hope that the board will approve this tonight. This is immeasurably better than what the board approved a few years ago and sent to the council for adoption. But I just want to go over, I know you're a planning board and you're supposed to be thinking ahead, thinking forward. I just want to go over for a moment the history of this. This plan was constructed pretty much in closed session by the board. I looked at the minutes, I saw some of the closed session minutes, I looked at the tapes. Sometimes you even went into executive session without reading the appropriate resolution, as happened today. We, meaning members of the public, found out about this when this was sent to the council and was on the council agenda, and we started to raise some questions. And fortunately, over time, the governing body agreed with the comments that were made by members of the public and came up with the plan that Mr. Barry is talking about, that I think is immeasurably better, that will result in far fewer units of housing, far fewer apartments, the exact same number of affordable units that we are required to do. And in fact, we found a lot of credits that hadn't been counted, so we actually lowered the amount that we have to construct going forward. Also, as a result of this, and as a result of comments that were made by the public and getting the Housing Authority and Sarah involved, there will be the housing that will be not primarily for, but will give preference to veterans. That I think is a good thing. So I hope you will pass this. But my point is this: had this been discussed openly earlier, we could have saved hundreds of thousands of dollars that were spent on professional fees, not only undoing what was done at the board level and getting the council to change what they were about to adopt, but we actually were able to get the Judge Natalia, to rescind his original decision, which is kind of unusual. I mean, that's a pretty good accomplishment, because he agreed that the plan that the council professionals came up with, based on comments from members of the public and certainly on their own expertise, was superior to the one that was developed by the board. And I think had this been done openly and people knew about this earlier, we could have had input into into the plan that you ultimately developed before it went to the council. It would have saved us. We were on the brink of having that plan adopted. In fact, it was adopted. The judge did accept it. And
Jimmy,
rescinded.
can you wrap this up, because you're really going on about past stuff that really doesn't
Well,
have
this is
anything to do.
something that you spent 2 years on, Mr. Chairman, in illegal meetings in executive session. So I think if I take 1 more minute to give some advice that perhaps you shouldn't be doing these things in executive session. When you go into, even tonight, you didn't read the resolution to go into
Jimmy. I'm
executive
sorry,
session. So you probably haven't learned that lesson. But my point, and I'll wrap it up, is very succinctly, if this stuff is done in the sunshine, it would have been a better plan, and it would have saved the borough hundreds of thousands of dollars in professional fees that were required to undo what was done in secret. Thank you for your time.
Thank you for your comments. Anybody else? Mr. Rittenhouse.
Mr. Chairman, Arthur Rittenhouse, 33 Delacat Lane. I just want to make a comment on Mr. Robinson. I was on the council at that time, and everything was fully presented. The council voted 6-0. They knew every single unit and what was going in every unit. So I disagree with what Mr. Robinson is saying.
Thank you very much, sir.
I do have one question on the Gillette Manor. It should be, I'm on the Housing Authority, that we did not put a specific number on that. The reason being, we would have eliminated moderate income Sayreville residents from being able to go into Gillette Manor. The way it is structured right now, we don't have anybody that fits there, but we do have the other 2 categories, and then Gillette Manor is full in that manner. So our attorney, Casper Bain, made sure that we weren't locked in to specific numbers. but we did say that we wouldn't meet all of the numbers required by the law.
Understood, thank you.
You up?
Ma'am?
Janice Benedetto, 1 Thomas Avenue in the Melrose section. Within 200 feet of the National Lead Cross Avenue, Oak Street property. And we have a lot of Melrose residents concerned about this. As you well know, we had obtained 485 signatures on a petition to have the acreage, almost 22 acres of wooded property, be bought for open space, which the borough has the money for. And we understand, that this is the best settlement we could end up with at this point in time. But if mistakes were not made in counting credits and things of that sort, the 7 units of affordable housing that are on this property are not even needed. They're excess above this particular phase of the COA requirements. But we were forced to, accept the settlement. At this point, then, it's a crying shame that almost 22 acres of wooded property and all of the wildlife on it are going to be destroyed when, in fact, the borough had the money, could have also supplemented the money for open space with grants. And National Lead had expressed an interest in selling it to us, and the Open Space Committee had recommended purchasing it. And we didn't need the 7 credits, but at that point in time, with the settlement agreement, the 7 units were the best that could be done because there already was a contractor ready to develop it who threatened to sue the borough. So this is a real crying shame that mistakes were made, things were carried out in the past that the way they were, and the quality of life in this borough is going to suffer for it. Innocent wildlife and other concerns such as floodplains and watershed and what have you areas are going to suffer for it. And it just needs to not happen again in the future, and that the Oak Street Cross Avenue development, as you're going forward and approving plans for it to make it the best possible development and keep as much open area as possible to make it a positive enhancement to the borough and the wildlife that we possibly can, to make it the best we can, because we have to live with it now. Thank you.
Mr.
Mr.
Bishara?
Shott, thank you. Before I don't know if you're gonna go through every ordinance or not, but let me
I
just.
believe we are.
Okay,
Yeah,
let me just state a couple things here, first of all. In the master plan, the Melrose section is not available. LU 25, LU 26, and LU 27 are not available. A person that's here tonight contacted the borough clerk. They've been deleted out of the master plan. That's number 1. Number 2, ordinance 44-19, there's something incorrect in that. 449-19. That's the one for development of Cross Avenue. Okay? And here's the problem. In the ordinance that Mr. Delino has presenting to the council, it's AH3 Zone 3, Block 297 Lot 1, Block 33 Lot 1, Block 32, 1, 2, 3, and 4. It's incorrect because on the registration through Trident Abstract Agency at 1340 A Campus Parkway in Wall Township, they did a transfer on 3/10/16, National Lead Industries Incorporated to Rockville LLC, ROCVILLE. And in that transaction, Block 291, Lot 1, Block 32, Block 1, 3, and 4, there's no 2, and Block 33, Lot 1. They did another title transaction on 12/18/18. I have the transaction ID, so that'll be on the record. The transaction ID with the Middlesex County Clerk's Office is ID number 2654092. Then, they did another transaction, the same parcels of property on 12/18/18. Transaction ID number 3675152. And in that transaction, again, the lots read as such: Block 297, lots 1, 3, and 4. Let me correct, I've made a mistake there. Block 297, Lot 1. Block 332, lots 1, 3, 4, no number 2. And Block 33, lot number 1. Okay, let me go on here with one thing here. With the ordinance that is stated, AH-3, Affordable Housing Unit Zone 3. You have a maximum height for townhouses, that's small I-1. Townhouses will be 2.5 stories, 35 feet. I-2, small i's again, affordable, that's townhouses. Affordable housing units will be 3 stories high, 48 feet. If you remember, when Kaplan built the houses in Town Lake, that he wanted to go beyond a certain footage, and this planning board denied him that. I would ask this planning board also to deny a 48-foot high building in this area because of the aesthetic. It's too high. It'll be an eyesore for the people that live there. It'll be an eyesore for the people that commute, either on the Parkway or on Raritan Street or off of Route 9. The buildings were going to be too high. If you have to build an extra building at 2.5 units at 35 feet, that could be acceptable, but nothing at 48 feet. Because yes, you do have, on Main Street, I can't think of, you mentioned the developer, that the affordable housing, 84 units.
Gillette Manor.
Gillette Manor. That's an abstract because it's actually in an industrial area. This is going to be an industrial area. 48 feet of height on a building, I think is ridiculous. And I hope that this board will reconsider that and make the amendments to bring it down to 35. And also, this ordinance of 449-19 is incorrect because it states 4 lots and there's only 3. And I gave you the transaction numbers. Thank you.
That has nothing to do with us, all of that, Robert. It's not in our purview. I'm being told by our professionals that that's a council issue.
Yeah, let me-
You as the planning board are going to approve this and send it to the council, am I correct? The ordinances.
This is a function, this is a referral function.
I'm sorry, say it again?
We are a referral function. The planning board is sent this information from the governing body. We assess it, and we either make a recommendation about it. We do not adopt it, we don't approve it, we can't change it, we have no power to change it. We can only make recommendations to the governing body that ultimately has the power to do these things.
Well, can you make the recommendations then?
Well, that's the pleasure of the board. However, this thing has been substantially studied. These recommendations are made pursuant to court order and the special master. I don't know how that, at this juncture, can happen, but if the board is of the mind to say those things when they refer this matter back to the governing body, they can do so.
I would highly recommend it because the people here tonight will recommend that. And I think the several residents will also go for that idea because of the fact of the aesthetics that you're going to create. Again, Town Lake, he wanted to build 3 stories and the board denied it. The board recommended to go to the council that you would not, am I correct, Mr. Ty? They recommended not to go to the 3 stories,
We did.
okay?
Yeah,
If
but
you did it
It
for
wasn't
Town
the
Lake.
3 stories, it was the lot coverage back then.
No, it was the
With
height
Town-
also,
with
Mr.
Town-
Ty.
Town Lake.
It was also the height,
Well, the
believe
first-
me.
You're right, the first time he came in, he wanted it grandiose.
Right, so if that's the case, you've done it once, you can do it again as a recommendation.
Yeah,
I
but
would appreciate it. I think
We
the
did
people
that
would.
in the process, not in where we're at now with this.
Well, I think what the chairman's saying, that was an application that
That
came
was an
before you.
application that was before us, and we acted like that.
It's
This
substantially
is,
different.
this is different.
but you still can make the recommendations and make changes.
And the board, if the board can feel free to do that.
You can still make changes, because the master
Oh, we
plan.
can make
can't
the
make
change,
changes.
we can make the recommendation to make the change.
Okay, that I would appreciate, I believe everyone here would agree with that.
I have one question.
Yes,
In the transaction
I'm
367.
sorry, my hearing isn't that great.
In transaction that you noted for December 18, 2018, transaction number 3675152,
That's correct,
you went 297, you shared about lot 1,
that's one,
right? 332, 1, 3, and 4,
correct,
and missing number 2. And then after that, did you say 33?
no, block 333.
Okay.
Okay, I'm sorry.
No
And that was
worries.
the same transaction also on the one on 31016, where they did a transfer also at that time.
Right,
And you have that transaction number? 2654092? That's on file with the Middlesex County Clerk's Office.
Yes, yes. Thank you.
I do my homework.
Yes, thank you.
Thank you.
George?
George Podolak, 48 Scott Avenue, the Melrose section.
Good evening.
Mr. Chairman, could you please tell me if the contamination has been cleared up on this, particularly the quicksand? Or are we gonna have a duplication of Scott Avenue contamination, where they spent up to $2 million already and still contaminated?
This is, it has, as far as I'm concerned, there hasn't been anything done, but it's not before us tonight either, George.
But if we pass the bill there, what's gonna happen? Are we gonna be
Well, when they
spending?
when they go to develop the property, they have to come in and lay everything out. If there's quicksand in there, they're gonna have to tell us what they're gonna do with it. If there's wetlands in there, they're gonna have to tell us what they're gonna do with it.
Has
and
this
all
been
of that.
brought up
It's
to the
at the-
builders?
It's gotta be brought in when the application comes.
A little bit late then, we spent over $2 million on 4 houses in Scott Avenue. One in particular was over $1 million and still contaminated.
Can only do what we're allowed to do.
Okay, then we'll have a duplication of Scott Avenue.
Oh, hopefully not. Hopefully when it comes before us, that with the right information, we can come up with the solution that you're happy with, George.
What kind of solution can we have for quicksand? Thank you.
And I'm not an engineer, so I wouldn't know.
Mr. Chairman, if I may, I'll run through these ordinances and then the public can have another crack at them if they like.
Should we?
Yeah, I would think, yes, we should let them go through the ordinance.
Okay.
But do you want to take action on the
No.
plan? Okay,
No, we're gonna go,
good enough.
what I just asked.
Gotcha. Couldn't hear you, sorry.
They're not part and parcel, so.
Yeah. So, the first ordinance, we'll just go numerically through them, 448-19.
Excuse me, Mr. Cornell's gonna step aside, he's got a zoning board
Yeah.
meeting, so if we need him,
I'll be back if necessary.
I'll give him a ring.
Okay. Ordinance 448-19 is, and again, these are, all four of the ordinances that we're discussing this evening are things that have been previously adopted. These are minor modifications as the changes to the plan were. The 448-19 is dealing with the AH-1 and AH-2 zones. That's the Camelot 1 and 2 properties, proposed developments. The changes are minor in nature. It says that includes that the deed restrictions and affordability controls for the affordable units will remain in place for at least 50 years, which is more than the typical 30. And then a change from our previous ordinance language said maximum density, 168 dwelling units for the projects, and the court master requested we change that to maximum number of units. So that change was made, and that is the sum total of the changes to 448-19.
Anybody from the board have any questions?
I don't know, I would let them go through all the ordinances.
All the
Yeah,
ordinances?
yeah, yeah, because
449-19, we got a little preview of, that's the NL property, and the changes to that ordinance are the same as the changes to the 448-19 regarding the number of units versus density and the 50-year deed restrictions. Regarding the question about the lot number that was raised, sometimes there are consolidations of lots. I'll be happy to look into it prior to the, returning to the council if the board likes.
You mean the issue the gentleman?
Yes,
gentleman-
regarding the lot number in question, whether we have lots 1, 2, 3, and 4, or if at this point it's just lots 1, 3, and 4, be happy to look into it and make sure that if there's a, whether it's typographical error or minor tweak, we address that. The next ordinance is 450-19. This is having to do with affordable accessory apartments in the office services overlays, which, again, were permitted by this ordinance that was previously adopted. The only change to this one is that all accessory apartments shall be advertised to and occupied by very low-income households. And that's to help the borough address its municipality-wide obligation to provide for a certain number of units for very low-income households. The final ordinance is 451-19, and this is actually an ordinance amending the River Road redevelopment plan. And we have two changes to this one. Originally, the plan was developed, there was still some negotiation and question of financial feasibility on the interested developers' end, so the plan was written for 60 to 88 affordable units. That's been changed to 88 affordable units, taking away the range. It's strictly 88 affordable units. And a minor change was made to the permitted density, where we had 6 dwelling units per gross acre. Previously, there was some language that said subject to environmental limitations. The court master felt that that language was sufficiently broad that it could lead to some shenanigans down the road. So that's been removed, and it just says 6 dwelling units per gross acre. So those are the 2 changes to the redevelopment plan, and that's the sum of the changes. Again, very minor modifications that were requested by the court master as part of the final settlement agreements.
Any comment on the ordinance changes from the board? Hearing none? Any comments from the audience? Arthur?
Arthur Rittenhouse, 33 Delacat Lane, Saraville, New Jersey. Just a quick question on 44819, where you changed the number to maximum. What kind of number is that going to be, maximum?
So the number itself did not change. The language changed. Previously it read maximum density, 168 dwelling units. The language was changed to read maximum number of units, 168 dwelling units.
Okay, so the 168 is still
And that
there.
was, yeah, and that's regarding the Camelot 1 development, and then similarly for the Camelot 2 development, it goes from maximum density 150 to maximum number of units 150. So the numbers themselves are exactly the same. It's a semantic change requested by the board master.
Then I have one other question, just the River Road development, that's the one that's gonna exit onto Saraville Boulevard, is that correct?
Yeah, I believe that's the location. Yeah. Yeah, it's the exits proposed through the senior housing on Saraville Boulevard.
I do have a concern that when we do things in the borough, we do section by section by section. You're gonna be getting in front of you the Fulton's Landing redevelopment plan that's coming up. In that plan, they're calling for truck traffic on the Main Street bypass, which is also Saraville Boulevard. Now, they've also called that no truck traffic can go west from the Mako property, so the trucks will not be able to go on Main Street. Does that mean they're gonna go through Saraville Boulevard up to Washington Road? Because they declared that Washington Road and the bypass are truck commercial things. My question is, did Rule, look at this? Did you look at these possibilities of the roads and things that are gonna happen? And I'll be back when you do Fulton to
Yeah,
talk to.
and I don't think that's before us right now, and I don't think it's
It's-
privy part of this process.
Well, if you're approving something or recommending something, and you're gonna have truck traffic now going, it was a residential area, I do think it pertains to this, that's all.
Look, the bottom line, sir, is if I can interrupt here.
Sure.
The changes to the ordinance are rather minor. These are all, but
Very de minimis.
they're minor, these were already approved. These is just some housekeeping things
That
that are.
wasn't my question.
that is- Yeah, I understand what you're saying, but as it relates to what's in front of us right now, we need to refer this back to council with a recommendation, up, down, or somewhere in the middle, or something of that
And
nature.
I don't disagree with
And that's
that.
our
All
fun-
I'm
that's our
saying
function.
is, in general, I think when we look at things, we have to look at the entire picture of the borough, especially when they're connected. That's all. Thank you for your time.
Ma'am?
Janice Benedetto, do I have to keep giving my address and everything?
Janet, you're all right.
All right, thank you.
Frequent flyer, you get a pass.
Yeah, okay. All right, on the ordinance 449-19, going word for word, line for line, paragraph for paragraph, I noticed a difference on page 5, letter E, exterior lighting. On the ordinance that was passed last year, 414-18, there was an addition to E, exterior lighting, paragraph small I, that said, an illumination shall be in accordance with IES standards. That's not on this, a new one. And this is in regards to exterior lighting fixtures shall not create excessive glare or light levels or direct light onto neighboring buildings or properties. So I do not know what IES standards are and why that is now not part of the new ordinance.
I'll say I'm confused because the copy that I have does not include the IES
The new
language that you're
one
referring
does
to.
not
I have
include it.
the previous one as well here. I'm afraid I don't know the answer to that question, but I'm happy to look into whether that language was in there.
Well, I have it, and this is off the website and what have you. So this is what was passed and everything printed off the website for
Okay.
ordinances. Okay, so
appears to
I
be
don't know what
different than the one that
IES
was-
standards are and
Yes.
how beneficial they are to
It's-
neighboring homes.
It's the Illumination Engineer Society. It's usually IESNA, North America standards.
It's like the
They're-
Traffic Institute.
Yeah, they're general standards that I believe the borough applies as a matter of course in its review process.
Which
So-
prevents, it prevents, excuse me, but, prevents spillover to adjoining properties, shielding, things of that nature. The degree of illumination cannot exceed certain levels, that's what the IES standards
I
do.
think
That
when you-
seems
when
like
you-
a good thing that should not be eliminated
Well,
from this new one.
when you questioned what we were doing the last time about that, this is almost what you wanted. The
Well, no.
exterior lighting fixtures not to create that's what, your point was you didn't want the glare and the level of lights flooding onto different people.
Right,
That
and the
paragraph.
old one had additional information that seems to be beneficial, and the illumination shall be in accordance with IES standards, which you're saying could involve shielding and things of that sort. That sounds beneficial to neighbors, and it's eliminated from the new one. So
Well-
it seems like something that was good is now gone.
I don't know the specifics about that, Mr. Barry's gonna have to check into that, but we do have those standards in your ordinance.
It's not in the new one. It's not in the 2019 one. That's a line that was taken out. That's what I'm saying. It was in the 18 414-18.
It's in the borough standards, not in this
Oh, it's in the
standards.
boroughs.
We have borough
Broader-
standards.
The
the
borough
universal
standards go
standards
In
through
the,
that. That's where the illumination comes in and all of that.
In fact, the borough standards, I haven't compared them.
Mm-hmm.
Borough standards could in fact be more strict than the IES standards.
Okay, well, that
Which could
would
be
a
the
good
reason
thing.
why they took the IES standard out.
Right, well, in your description of what the differences were, that's a difference you did not mention. And
It's
I
not
would
on my
like,
version, that's why I didn't mention it, I apologize.
it's not on your version of
It's-
414-18.
It's not, so
Okay.
perhaps the version that was adopted was modified after it came out of my office, which
It
is,
could be.
which is a possibility.
And
The
that's why
council-
we
The
use
governing body
our,
has the opportunity to do that, so.
yeah, that's why we use the one that is published
Right.
on the website, and it has all the stamps and what have you, as far as first reading on May 29th, 18, and, advertised according to law on 6/2/18, and adopted on second and final reading 6/25/18, advertised according to law 6/29/18, and it's signed by, Terry and all of that. So we compared it to the final. So, if it's better, that's great,
Right.
but that's just something that, as you're making your recommendations to the council, maybe needs to be looked into.
Yeah, we're not gonna be in a position to do that tonight, more than likely, but we will certainly, Hiram will certainly look into that issue.
And again, this is a relatively de minimis tweak, especially if it was in the previous adopted version, then I don't think the intention was to eliminate it. I'm sure that we can address it with the council.
I appreciate that a great deal. Thank you.
Anyone else? Everybody satisfied? Motion to close the public portion?
I'll make that motion.
Second? Second. All in favor? Ladies and gentlemen, what's your pleasure?
I think we have to entertain, a motion with respect to, the recommendation of the proposed adoption of the amended housing element fair share plan in conjunction with the four ordinances that we went through, with the changes, that we discussed.
I'll make that motion to approve.
Do I have a second?
Second.
All in favor? Roll call? Roll call vote?
Mr. Herkovich,
Yes.
Councilman Delana, Mr. Davis, Mr. Kelly, Ms. Lee,
Yes.
Mr. McEnroe.
Yes.
Ms. O'Leary,
Yes.
Mr. Velocin,
Yes.
Ms. Matilla,
Yes.
Chairman Pai,
Yes.
motion granted.
Just for the board's edification, the public, I did prepare a draft resolution memorializing what the planning board just did, given the fact we have some upcoming target dates that that we need to meet with respect to the affordable housing litigation, to finalize this matter before the court. So there is a draft resolution in front of you that basically discusses making the recommendation to, yep, that's it.
It's the one page that has everybody's name on the bottom.
And that's a draft resolution that recommends to the council to move forward on these issues, specifically the adoption of the amended housing element fair share plan and the four ordinances that have been testified to by Mr. Barrett. Yep.
I need a motion. Okay.
We should just add one provision here where it says, now therefore be it resolved to include the four ordinances. I want to be clear about that. It recommends adoption of the amended housing element fair share plan that includes the ordinances, but I think we should include the reference to the ordinances specifically in the therefore clause. So there's no question. I can make that change as long as you adopt it.
Good. You make a motion?
Yeah, make a motion that we approve the resolution on what we just voted on this evening.
Second.
All in favor? Roll call?
Mr. Herkovich?
Yes.
Councilman Delana? Mr. Davis? Mr. Kelly? Ms. Lee?
Yes.
Mr. McEnroe?
Yes.
Ms. O'Leary?
Yes.
Mr. Velocin?
Yes.
Ms. Matilla?
Yes.
Chairman Ty?
Yes.
Motion granted.
Mr. Barry, thank you very much for your help.
Thank you for your time this evening.
Do you have anything else from us?
You can make those changes and.
Yeah.
More open to the public?
As long as you discuss this.
I need a motion to adjourn.
I'll make that motion.
Second?
Second.
All in favor?